Good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. Welcome to this morning's webinar, where we're going to be talking about basics of the right to know law. Everything you need to know about filing right to know requests or responding to right to know requests, depending on which side of the fence you're sitting on. A couple preliminaries before we dive into the topic. First, if you've ever attended one of these webinars before, you'll know that it's basically a PowerPoint presentation with me discussing points in the background. The PowerPoint is available on our website underneath the training tab, along with all of the PowerPoints that we use for our trainings. You're welcome to access them, download them if you have the need to do that. Who knows, there may be a colleague of yours who wasn't able to attend this morning and they'd find the PowerPoint helpful. Maybe you're doing some localized training and you need some resources. We consider these PowerPoints to be public records, and you're welcome to use them as you see fit. Sometimes it's just good to have them available for your own reference if you're dealing with a right to know request and you need some advice or some guidance on how to proceed. Also, this session is being recorded and the recordings are available. What will happen is one of the administrative staff in a day or two will download the recording and then upload it to our YouTube channel. And from there, they make a link on the website. And again, you go to the training tab, scroll down, pardon me, and you can find the recording that we're making right now as I speak. So that is also available for your own reference. And again, if you have localized training or maybe some friends or family who couldn't attend today, you can refer them to the recording. Questions. Okay. First offhand, you're able to submit questions using the chat feature, and I will do my best to answer them live as we're going through the presentation. But there are two conditions. First is we're talking about the right to know law, so let's keep our questions on topic. Second, and just as important, is the shorter, more concise you can be with your questions, the easier it is for everyone. Sometimes folks will type in several paragraphs and it's just awkward for me to sit here and read through a lengthy question while everyone else is waiting patiently. If it looks like you've got something unusually complex or maybe specific to your situation, we'll do one of two things. We'll either wait until the end of the presentation and come back to it for the good of the order, or we'll take the conversation offline. The contact information for the office is on the screen right now, our phone number and the URL for our website. On the website, there are email accounts that you can access. You submit your questions or you call in, and you're going to get a hold of one of the administrative staff. And they're very experienced, very well versed on the right to know law. Usually they can help you out. If you've got something that stumps them, then your request gets escalated to one of the senior staff, and they're very good about getting back to you, usually within 24 hours. We realize that if you're contacting us, it's probably something time sensitive and it's probably something important that you need to resolve. So we try to get you headed in the right direction as best we can. Okay, so I think that takes care of all the preliminaries. Let's go ahead and dive into this and start talking about the right to know law. Okay, well, first offhand, why is it important? And, I'd like to reference a couple different factors here, access, transparency, and good government. And I think it's important to go back to this fundamental statement about what the right to know law is all about, because there's a lot of misunderstanding. People see that term right to know, and oftentimes they interpret it as some version of Google for government, state and local government. And that's just not the case. The intent of the right to know law is to give the public access to public records, no more, no less. Okay, so a lot of times people will just write out a series of questions on a right to know request without ever really referencing any documents or records. And that's not right. Okay, that's not the purpose of the right to know law. And many times those sorts of requests will get denied because they're not specific enough. They're not identifying a record that the person is seeking. Okay, so a lot of times what I suggest is if, for instance, if you're an agency open records officer and you get stuck, you're not quite sure how to proceed, come back to this fundamental statement. And a lot of times that will get you more or less rebooted, reoriented, and headed in the right direction. Okay, my job is to provide public records in response to this request. Okay, how do I proceed from this point? Now, there are some caveats, though, that are associated with this that are very important for everyone to keep in mind. Sorry about this cough I have. I forgot to get some water here. But first is that your starting point is that every record of an agency is presumed to be public. Okay, that's where you start from. But if a request is received and let's say a red flag goes up, you're thinking, I just don't feel comfortable with the idea of releasing these particular records because of, some potentially sensitive information. It is the agency's burden. And when I use the term agency, that's generic. It could refer to a cabinet level agency in state government, a board, a commission, or you go to local government. It could be city, borough, township. It could be an authority created by statute. It could be a school district. It could be, an extension of that. It could be a charter school. That's what an agency is, okay? Any government entity that's subject to the right to know law. But it is that agency that bears the burden of proving that a record is not public, okay? They have a legal test that they need to satisfy, that they can't just say, well, this is none of your business, but rather they have to turn around and say, it's none of your business because of this provision within the right to know law, or this other law says that these records are confidential, or there's case law that specifically covers this particular issue. And that court case, the language in the court case denies access to these sort of records. Okay, but it's the agency that needs to prove that at a legal and factual level that these records are not public, okay? The person submitting the right to know request bears no burden for that proof. Only the agency does. Okay, now this seems rather daunting. If you're someone new to the right to know law and you're working in an agency and you get your first right to know request, you're thinking, oh my gosh, everything in the office is going to end up on someone's Facebook page or on the front page of tomorrow's newspaper. And, I'm here to tell you that that's not the case. There are tools, many of which I just mentioned, that an agency can use to deny access to records if there is sensitive information, if it is covered by the right to know law, another law, or, perhaps a court case as well. And we'll be discussing those as we proceed through the presentation. Okay, moving on. Something that I also need to emphasize is that the right to know law is not a confidentiality law. Okay, what does that mean? Let me translate this to English. First offhand, there's nothing in the right to know law that prevents an agency from just giving out records. Okay, it's not unusual to get a phone call or an email from someone working in an agency. Hey, I got a right to know request. Am I allowed to give these out? Okay, well, under the right to know law, the answer is yes, you are, unless, there are certain conditions that need to be met. But, there are some records that are inherently public by their nature. And we list some here: budgets, contracts, salary information, purchasing documents. Okay, all stuff that typically would be released through the right to know process. But the thing is, there's nothing in the right to know law that says you must use a right to know request before you give out a public record. A quick example, let's say it's budget season and the agency has been working on this and they have a stack of draft budgets available. Okay, and they've been talking about them in meetings and workshops and so forth. And I go into the office as a member of the public, and I say, "Can I have a copy of the budget?" And there is absolutely nothing in the right to know law that prevents you from handing me a copy of the budget. And I walk out a satisfied customer. Okay. There's nothing in the right to know law that says this sort of record is confidential. As a matter of fact, I could come walking in with a right to know request and that asks for a copy of the budget. And the agency could say, "George, you know what? It would save us a lot of paperwork and it would save you a lot of time if you just tear up that right to know request and we'll give you a copy of the budget. You can do that." And why wouldn't I go along with that? Because I'm getting what I want. I'm getting a copy of the budget. Now, an agency at its discretion can require a right to know request prior to giving out a public record. But there's nothing in the right to know law that demands that, okay? It's purely at the discretion of the agency if they want to require a right to know request before they would give out any public record. Now, some of the most commonly sought records, we suggest that you be preemptive and put them on your website or whatever social media platform you might have. And I reference these again: budgets, contracts, salary information, purchasing documents, as just some more common examples. What happens when you do that? First offhand, it's just good public service. It's good customer service because the public kind of has come to expect that as we become more involved in the world of the internet and so forth. It's just much easier to sit in your family room, surf your municipality's website, find the records that you need, and without ever having to file a right to know request. So what we suggest is take a look at your history of right to know requests, identify trends. What records are people most often seeking? And then put those records up on your website. Next time someone files a right to know request for one of those records, the agency response can be, "That's on our website. Here's the URL for it." And that is a valid response under the right to know request, under the right to know law. The other thing is that you'll notice hits on your website will start going up and right to know requests will start going down, which saves everybody a lot of work. Okay. And that's a good thing. So something to consider. There's nothing in the right to know law as far as state or local agencies go that you must use your websites. But we have identified it here at the Office of Open Records as a best practice. You know, there are some agencies that really have this down and they use their websites as business platforms to get as many records out there as possible. Okay, a couple questions have popped up here. Do you need a right to know request to go in and view the record like a budget? That is again, at the discretion of the agency. They may be perfectly fine with you going in and saying, "Hey, can I view the copy of the budget?" Or they, within their legal rights, can say, "Well, you need a right to know request to," and the appropriate term under the right to know law is inspect the record. Okay, I would like to inspect the record, and that's how you would view or check off the right to know request form. Okay, but again, it's a good question, and it's at the discretion of the agency as to whether they would require that. Now, for your example of someone bringing in a right to know request form for the budget, suggesting they tear it up and hand them a copy, why would the form need to be torn up instead of just accepting it and handing out the requested item? Okay, Elizabeth, that's another good question, and it comes down to paperwork. Okay, if you want to accept the right to know form, there may be steps you then have to subsequently go through because you have to provide, remember, you have to provide a written response to the right to know request. So if you decide to accept it, you're legally bound then to provide a written response, which is, let's be honest, that's more paperwork. Whereas if you tell the person, look, here's a copy of the budget, you tear that up, I'll give you what you want. Okay. You're not violating any law, and you're saving yourself a lot of work. Okay. So hopefully that you see my logic there. And like I said, you're not violating the right to know law by doing that. Okay. Because like the slide says, the right to know law is not a confidentiality law. The other thing we're going to be talking about are the exemptions. And I want to emphasize that the exemptions are also discretionary. Just because it's mentioned in the right to know law does not mean that you must withhold a record. The exemptions basically say you can withhold a record if it meets these standards. Okay, hot bench today. Another question has popped up. If they do not use the word inspect, can the right to know officer tell them they must make an appointment? Or should we just make the copies and go forward? Okay, Vicki, in that particular instance, if there's ambiguity, I would start a conversation with the requester. Do you want copies or do you want to inspect? And then that will hopefully add some clarity and you would know how to proceed from there. You guys are getting ahead of me a little bit, but one of the things I would emphasize is that there is absolutely nothing in the right to know law that prevents you from talking to each other. And a lot of times that can solve problems, okay? That can add clarity to the situation so that everybody knows the appropriate way to proceed. Does it have to be documented that you gave out the budget without completing the right to know form and that you verbally directed to the website? Okay, 2 questions there. The first half is that if you just hand out a copy of the budget, no, nothing needs to be documented as far as the right to know law is concerned. Okay, it's simply a conversation between a citizen or a resident and the agency. Whether you choose to document that or not is up to you. Now, if you receive, that you verbally directed to the website. Okay, if it's a verbal conversation, then that does not need to be documented either. If someone submits a written right to know request and you accept it and process it accordingly, you would be obligated to issue a written response that directs the person to the website. Okay, but again, hopefully you see where I'm coming from here with a little bit of common sense. You can meet the spirit of the right to know law, giving out public records in response to the public requesting them, without necessarily having to follow the prescribed procedure that the right to know law demands. Okay, now if you accept the right to know request, you have to follow the procedure. But if you can satisfy the request, or I should say the requester, without formally accepting it, that saves you a lot of paperwork and a lot of time. And the requester gets what they're asking for, usually a lot faster. And that's the spirit of where I'm coming from here. And I just want to make the point that you can do that, and it's not a violation of the right to know law. Now, as far as salary information, can it be generic, such as salary for roadmaster, supervisors, employees, or must we list the names of the employee? It depends what the person is asking for. Salary information of government employees is public, okay? You can go, well, not anymore because I'm a consultant, but you could find, I guess you could find the contract information for me. But when I worked for the Commonwealth of Pennsylvania, you could go to a website, search on my name, and you would find out how much the state of Pennsylvania was paying me. Okay, so to answer your question, if the person requests, how much does this person make? And they name names, your response would be to provide a record that reflects how much that person makes. Okay, now if they ask how much does the roadmaster make, then you would, your report or your record would indicate roadmaster. But if the roadmaster's name is John Smith and the request is how much does John Smith make, you would provide John Smith's name. Okay, there is nothing secret about the compensation of public employees. Okay, that is a public record. Okay, good questions, folks. Keep them coming. All right, so let's move on. We will assume that your agency is subject to the right to know law. Well, there are some things that they have to do, or you have to do. First, and probably most important, is that you appoint an agency open records officer, what we call an ARO. This is the same as a right to know officer. The two terms are interchangeable. They mean the same. Okay, you can come up with your own local regulations and policies for administering your open records program as long as they don't conflict with the right to know law or any rules that have been established by the Office of Open Records. I gave you one example as to whether or not you would require a right to know request prior to giving out any obviously public records. Okay, that's at the discretion of the agency. Another one, this one's kind of interesting. There is a phrase in the right to know law that says an agency may grant anonymous requests. Okay, well, there's another law in Pennsylvania. It's called the Statutory Construction Act, where that word may also means may not. Get that, okay? So you break this down, an agency under the right to know law has the right to deny a right to know request if the person doesn't identify themselves. So they could embrace that as a local regulation or local policy, that we will only honor right to know requests where the person is telling us who they are. Okay, another question has popped up. So if they ask for Joe's salary, we can provide just Joe's. Okay, I'm not sure where the confusion is, but the answer is yes. Okay, public employee salaries are public records. All right. Yeah, moving on. Oh, yeah, many agencies can come up with their own right to know form, and most of them do. They like to have their seal at the top. Perhaps they have contact information for the ARO. They may list cost information, contact information, et cetera, et cetera. However, if someone comes in with the state form, which is on our website, you must accept that in addition to whatever required forms you would have available. Okay, so if someone comes in with the state form or what's known as the uniform request form, you must accept that. And there's not necessarily anything special about that form. Again, it's on our website. Many agencies will simply link to that. And then finally, we ask that you provide us here at the Office of Open Records with the name and contact information for your ARO. On our website, we have a searchable database of all the AROs in Pennsylvania. Okay, but a good many of them, we rely on voluntary compliance. And we realize, people move on, they retire, they get promoted, whatever. So they change. And it's not unusual. Number one, we will get requests from the public. Say, I was on this agency's website. They don't mention anything about the right to know law, and I want to file a right to know request. Who's their ARO? So we'll direct them to our database. Or if an appeal gets filed, it's the person on that database that we reach out to. So if that information isn't up to date, okay, it creates problems. And it creates problems more for the agency than it does for us, okay, because we're working under legally mandated deadlines, and so are you. So your information needs to be up to date. So take a look at our website, make sure your agency's information is accurate. If not, there's a form available for you to fill out, email to us. We will verify it, and then we will update the database accordingly. Okay, you're required to have postings on your bulletin boards physically at your office. And if you have a website, it needs to be on your website as well. The purpose of the postings is to educate the requester. Look at this from the public's perspective. Okay, they don't work with the right to know law typically, all right, and they know very little about it, but they have a problem. They need a record from your agency. So how do they do it? Well, they use the right to know law, all right, but you work with it, or the agency works with it more often, so they are a little more familiar. So use this as an opportunity to educate the requester. Let them know what the playing field looks like before they enter the game, so there's no surprises. Your posting must include contact information for the arrow. If you deny their request, what are their options? What are their appeal rights? Typically, they would file with the Office of Open Records. So we recommend that you give them our website address, because everything here is pretty much automated and they can file appeals right on the website, and it interfaces with our docketing system. Then you need to have a form available so that, if they don't have a form, they can get one from you off their bulletin board or your website. They can download it. And then finally, you want to let them know any of those local policies or procedures that you've instituted, again, so that there's no surprises. Nothing upsets a person more uh, to be blindsided by some local rule or regulation that they weren't expecting, that slows down or confuses the process. So the more transparent you are, the agency is, with what the person needs to do in order to get the record that they need, the fewer problems you're going to have and the fewer misunderstandings you're going to have. So, it's a good thing to communicate all of this information up front. Okay, so there are some things that agencies cannot do relative to the right to know law. Let's talk about that. The first is that you can't limit the number of records or right to know requests that a person files in any specific time period. You can't say something like, ma'am, I'm sorry, you already filed 3 requests this week. That's all we allow. If she's inclined to file a dozen requests, the law allows her to do that. And then you can't compel a person to tell you why they are filing a right to know request. You can't deny a request based on the reason or what you think that reason is, even if it's to see you work harder. Okay. Now, the greater majority of people file right to know requests for legitimate reasons. You have a record that they need, so they use the process to get a copy of that record. I'm the first one to admit that there are a handful of people out there who, for whatever reason, the relationship between them and the agency has broken down. They've decided they're going to be a pain in the neck. And one of the ways that they're going to be a pain in the neck is to weaponize the right to know process. I've worked in this world for, I think, Office of Open Records for about 12 years now. And I can tell you that the best way to make these people go away is you're going to find it on the payment side of the right to know law. Now, we'll talk about that briefly here today, but we also offer a webinar on the right to know law and payment issues, where, if you have one of these problem requesters, I would suggest attending that webinar. And if you are one of these people attending today, well, shame on you. We'll take care of you later. Okay. But yeah, you cannot force a person to tell you why they are filing a right to know request, and you can't deny a request based on whatever that reason might be. Okay, moving on. I like to describe the right to know process as an obstacle course. Okay, on this obstacle course, there's a starting line. There are 2 hurdles, and in front of the second hurdle, there are 3 hoops that you have to make it through before you can jump over the second hurdle. Jumping over the second hurdle, you're basically saying this is a public record and you're granting the request. Okay, so let's start by taking a look at what happens at the starting line when you receive a request. The agency needs to note the date that it receives the request, because, as I indicated earlier, there are legally mandated deadlines built into this law with no flexibility. So by noting the date that you receive the request, that memorializes the start of the race through the obstacle course. And it's because there's a 5 business day deadline in which the agency must provide a written response. And it's called an initial response. Now, it's 5 of the agency's business days. So if you're, a Monday through Friday operation, it's pretty easy to figure that out. However, holidays are not considered business days. Weather closings or some other emergency closing would not be considered a business day. And like if you get up into the upper tier of Pennsylvania, you'll find many municipalities are not open 5 days a week. They may only be open, let's say, 2 days a week. So your 5 business days would be, let's say you receive a request today. Tomorrow would be your first business day. And let's say it's Thursdays and Fridays. So, you've got Thursday, Friday. Then you go to the second week, Thursday, Friday. Then you go to the third week, Thursday. Okay, there's your 5 business days. So you see how that works. Okay, so it's 5 of the agency's business days. You want to maintain a copy of the request. And we get into retention issues sometimes, but I'll just say this. The right to know law says that you must maintain a copy of the request and all associated documents for 30 days or until all appeals have been exhausted. Now, right to know requests can get appealed all the way up to the Pennsylvania Supreme Court, and that can take years. Now, chances are if a request is being appealed for the agency, they've got a solicitor who is working on that. So they're going to have copies, but the agency should have copies as well. But there is another law in Pennsylvania. It's known as the Pennsylvania Municipal Records Act. And they amended it after the right to know law to say that right to know materials you should keep for 2 years. Now, it only applies to municipalities, cities, boroughs, townships. It does not apply to school districts or authorities. And at this point, I'm not aware of any legally mandated retention schedule for school districts. Okay, for whatever reason, they just don't have it. But for our purposes here today, I would recommend holding on to everything for 2 years, after which, if there's no more appeals that you need to worry about, at that point, you can dispose of them per your record retention schedule. And if you don't know what that is, take a look at the Municipal Records Act or reach out to the Pennsylvania Historical Museum Commission, which oversees the Municipal Records Act. And they have some good people there who will help you out with all of that. Okay, questions have popped up here. 5 business days expires at midnight, correct? No, not necessarily. It would be the close of business for most. But again, it's at the discretion. If they say midnight, yeah, I'm going to say it's at the discretion of the agency here, Chris. My world is in appeals, and that is midnight. But for requests, I think it's close of business. But the agency can say close of business is at midnight. For our purposes here, like let's say 5 o'clock would come around and you didn't hear from the agency, I would wait until the next day, okay? Because, I don't have time to get into all the details here, but what if their response is mailed? And here at the Office of Open Records, we allow, I think it's like a 2 to 3 day grace period for an agency if they choose to use the public mails to send a response. So I would say, just sit tight. And again, there's nothing wrong with reaching out to the agency. Did you respond to my right to know request? And that will tell you how you should proceed with whether or not you want to file an appeal or not. Okay, talk to each other. That can solve a lot of problems and save you a lot of work. Confirm that if a request is sent after normal business hours for the agency via email, that you would note the date of receipt as the following business day. Well, Amy, it's going to depend. If it's sent after business hours, and if you receive it first thing that morning, that's your first business day. But if it comes in, yeah, okay. if you get it first thing in the morning, that's your first business day. But if it like comes in, at 4:54 in the afternoon and you guys close at 5, the next day is your first business day. Okay. Um, it can also depend on when you get the mail. Okay. If it's waiting for you when you come in the office, that's your first business day. If the mail doesn't show up until later in the day, even if it's later in the morning, the next day is your first business day. Okay. It's basically a full business day. You have 5 full business days in which to provide your initial response. Okay, so you take it from there. When did you get the message? When did you get the request? And calculate it accordingly. Hopefully that makes sense. Okay, let's move on. I tell you right now, folks, we're going to run over, but that's okay. If you have to leave, I understand, but I'm going to take as long as it takes to answer all your questions. Okay, now, let's say that the agency, for whatever reason, is unable to provide an initial response within the 5 business days. They are unilaterally allowed to invoke a 30 calendar day extension. Okay, so notice the change in terminology here. It's not a business day. We're now with calendar days. So that would include Saturday, Sundays. It would include holidays. It would include weather closings. Okay. You simply look at the calendar, figure out what would otherwise be your 6th business day, or the day, actually, it's the day after your 5th business day, and count 30 days. Okay. And that's how you would calculate the 30 calendar days. However, in order for the extension to be valid, there are some conditions that need to be met. The first is that you must invoke the extension within the 5 business day window. You can't wait until what would otherwise be your 6th business day, suddenly realize, oh my gosh, I forgot about this right to know response. Well, we'll just take an extension. Okay. By missing the deadline, you have denied the request by default. Legally, it's what's called a deemed denial. You'll see that term periodically. And if there's a deemed denial, the clock has started ticking on the appeal phase. Okay, you've missed your chance to respond. Okay, but if you haven't missed it, you can take the extension. You must notify the requester in writing that you're taking the extension. You have to provide a reason why you're taking the extension. And if you go to section 902 of the law, it lists 6 reasons. For instance, we keep these records off site. It's going to take us longer than 5 days to go look through them. Or we want our solicitor to review our response to make sure we're not giving out anything we're not supposed to. And it's going to take longer than 5 days to do that. Okay. You can check off the appropriate reason that applies to your specific case, and you've satisfied this requirement. Then you need to provide a date on when they can get the response, or when they'll get the final response. Usually that's the 30th day of the extension. An estimate of any costs that the person can expect to incur. And it is just an estimate. It's not a hard quote. You settle up on the exact amount when you provide the actual records. So you've got the 5 business days and then the 30 calendar days. That represents the agency's window to respond. Okay, suppose the right to know officer is on vacation. When does the date start? Okay, Audrey, you are actually raising an issue that is clarified with a court case, Donahue versus the Office of the Governor. Okay, and essentially what the Pennsylvania Commonwealth Court said is that the clock starts ticking when the request is received by the right to know officer. So if they're on vacation, the clock doesn't start ticking until they return from vacation. However, remember what I was saying about communication. You'll actually prevent a lot of misunderstanding and problems for yourself as well if you notify the person right away. that when it comes into the office, our right to know officer won't be back until next Monday. So the deadline gets extended until they, it starts when they return. So that way everybody has the same understanding as to when the deadlines come into effect, okay? Because they may not know that the right to know officer is on vacation, okay? So you need to communicate back and forth. And that'll hopefully, solve any problems before they become problems. Can you say the doc will be sent within the legal period? I'm not sure what that means. You're either granting the request or you're denying the request. Okay. What legal period means, I think, I think I know what you mean, and on the extension. No, no. And I'm going to get into this because I think you have a misunderstanding as to what these deadlines mean. The deadlines are when the response is due. The deadlines are not, they do not dictate when you must provide the records. And I'm going to get into that here in a little bit, okay? All right, so we come up to the first hurdle. And in order to make it over this hurdle, we need to determine, is the person requesting a record? Okay, well, that seems rather obvious. Okay, why would that be an issue here? Well, whenever you're trying to understand a law, I always suggest that you make sure to read the definition section. And the right to know law is no different. Now, the right to know law, again, you can download it from our website for free. It's not a long law, and for the most part, it's written in English. And if you go to the definition section, it actually defines what a record is. And you're going to find this very helpful. It's any information, regardless of its physical form or character, that documents a transaction or activity of an agency and is, et cetera, et cetera. Okay, key phrase in red, documents a transaction or activity of an agency. Let me translate this into English. It means that a record has something to do with what the agency does, okay? It reflects the mission or activity of the agency. Now you're going to say, okay, well, why wouldn't it be a record? Let me give you an example. Let's say that a restaurant's opened up downtown and I send an email to one of my colleagues and it basically says, hey, did you hear about the new restaurant? Let's meet for lunch tomorrow. Okay, and I send that to my colleague. Now that is, a fairly common example of a communication that you would find in an office setting. However, it has nothing to do with the mission or activity or transaction or activity of the agency. So it doesn't rise to the definition of a record for purposes of the right to know law. So I could, send a message like that. I could send a message, hey, what do you think of Jalen Hurts' progress so far this season? Do you think they have a shot at the Super Bowl? Or I could say, I'm picking up a gallon of milk on the way home tonight. All right, all fairly common messages that you would find by scrubbing my emails, okay? But they would not be subject to the right to know law because they do not rise to the definition of a record under the right to know law. So I don't have to worry about stuff like that being released through the right to know process. You see how that works? They're not a record, so they would not be released. They don't make it over the hurdle. So you're off the course. Okay, you lose. Okay, it has to be a record. Now, something I need to emphasize here. Let's say I'm texting one of my coworkers and I text a message about the case I'm working on. Could you send me the filings for this particular appeal? Because I want to look at them while I'm traveling to this training I have to give. Okay, now that I am talking about work of the Office of Open Records. And even though I'm using my personal cell phone to do it through my personal texting account, it would still be considered a public record because it is the content of the message that determines whether or not it's a record, not how the record is created or where it's stored. Okay, so the fact that I'm using my personal cell phone, there's nothing illegal about that. It just makes it a little awkward because that record, that text message, is a public record, given the definition of a record and a public record under the right to know law. Okay, if you deleted your messages and no longer have the record when a right to know request comes in, okay, well, there's a couple dynamics to this. But the bottom line, it comes down to possession. You're only required, for the most part, there are some exceptions, but you are only required to provide a record that you have in your possession. If the record has been deleted, and understand that in many instances, if it's electronic, you think you've deleted it, but it's still out there somewhere. Okay, and that's subject for another discussion as to whether it's truly been deleted or not. But for the most part, if you no longer have possession of the record, you're not required. And how can you provide it if you don't have it anymore? Okay. Can a non-record correspondence be redacted from documents that would otherwise meet the definition of a record? Yes, very good question. And many times that's what you do. You redact. For instance, you'll find that now it would be considered, well, no, it wouldn't be considered a record. Let's say you have an otherwise public record, but on that record, there's a Social Security number, which clearly would be a confidential, sensitive piece of data. You would redact that Social Security number and then provide the public record. But understand, you need to tell the person what you've redacted when you send out your response. Behind the redaction, there is a Social Security number, because a redaction is a denial. Okay, you are basically telling the person you can't see this part of the public record. So you let them know why. And that way, again, you might save yourself some trouble by explaining it's a Social Security number. Okay, so we have now an understanding. Is it a record and what a record is under the right to know law? Now we come up on the second hurdle, where we've got to answer the question, is it a public record? And this is a more involved exercise here because we have these three hoops that we have to go through. The first hoop, we have to answer the question, do any exemptions apply? And if so, are we going to invoke them? All right, what's an exemption? Well, we go to Section 708B of the Right to Know law, and we're going to find 30 exemptions. An exemption is a definition of a type of record that can be withheld under the right to know law. Exemptions, they cover an incredibly broad spectrum of types of records. And for the most part, they all make common sense as to why you wouldn't release them. For instance, there's an exemption, I think it's 708B1, that says, if by releasing this record, you would put someone in physical danger, you can withhold it. Or we're not going to give out health records of public employees. Or we're not going to give out any records about minors, okay? All exemptions within the right to know law that by citing them, you would meet your legal obligation for denying a right to know request. Okay, a very powerful tool. Okay, question has popped up. I have several requests concerning right to know, and they want purchase orders, blah, blah, blah. They also state that if we let them know what kind of software we use. Okay, I know exactly who you're getting the request from. Yeah, it is a problem. Number one, Elizabeth, I'm assuming you're new to this, okay? Number one, you do not have to create a record in order to respond to a right to know request. Number two, and by, filling their template in essence, you're creating a record. I think that's probably the best course of action with dealing with this particular company. I'm just going to let it go at that. Okay, Elizabeth, you might want to reach out to our office, but keep that in mind, folks. You do not have to create a record in order to respond to a right to know request. Although sometimes, it's easier just to create a record than it is to deny it. Okay, to save yourself a bunch of work. You don't have to do research. Okay. And you only provide records that you have in your possession. You don't have to go looking for records that you don't have. Okay, so keep that in mind. Remember, go back to that fundamental statement at the beginning. The purpose of the right to know law is to provide the public with public records. Okay? All right, back to the slide. So the first hoop, in order to make it through that hoop, we have to decide whether there are any exemptions that apply. If not, we can make it through the first hoop. Then we come up to the second hoop, where we have to answer the question, are there any federal or state statutes or a judge's order that make these records non-public? And this is referenced in Section 306 of the Right to Know law. If there is a federal statute that says a record, or a state statute for that matter, that says a record is confidential, that trumps the right to know law. Okay, and the right to know law says this. For instance, you get the alphabet soup of health-related federal legislation, HIPAA, FMLA, the Americans with Disabilities Act. Okay, all of those deal with health-related records, and it says these records are confidential. Now, there's language in the right to know law. There's actually an exemption that covers this, but even if they didn't, the federal statutes and their confidentiality provisions trump the right to know law, okay? And they do not give you the same discretion that the right to know law gives you. The right to know law says you may withhold a record if one of these exemptions apply. This federal statutes say you cannot give out these records, and usually there's a sanction attached to it. If you're here from a school district, you're more than likely familiar with a law called FERPA, the Family Educational Rights and Privacy Act, which makes it illegal. Actually, what it says is we will withhold your funding if you wrongfully give out individual educational records. Police departments deal with a law called CREA. There, it does say it's illegal to give out certain criminal records, okay, that are not mentioned in the right to know law. So in order to make it through this second hoop, you would need to determine that there are no other statutes that make these records confidential. And it so happens we have another webinar where we talk about laws that protect information. I think that's in 2 weeks, as a matter of fact, where we discuss this. All these other laws that we typically run across here at the Office of Open Records that deal with confidentiality provisions. Okay, and then we have a third hoop where we need to answer the question, is the record protected by privilege? This is usually attorney-client privilege. Typically, it deals with correspondence between a solicitor for a municipality and the elected officials and senior management. So that if your solicitor sends an email providing legal advice or sensitive information to the agency, it's protected by attorney-client privilege, and it's not subject to the right to know law. Okay, so we've got these three hoops. If there are no exemptions, or if there is an exemption and we're choosing not to apply it, we make it through the first hoop. If there are no federal or state statutes or a judge's order that says these records are confidential, we make it through the second hoop. And then if it's not protected by attorney-client privilege, we make it through the third hoop. If we make it through all three hoops, we can then jump over the second hurdle, and we're basically saying it is a public record. It can be released to the public as a responsive record to the right to know request. And that's how we make it through the obstacle course. Okay, so what we've done is we've either granted or denied the request. In this case, we're granting it. They've made it through the obstacle course. But there are some things that we need to know as we come up on how is the person going to pay for it if there is in fact a charge. Let me just sip of coffee here quick. Okay. First, you should be made aware of Section 701 of the Right to Know law. I'll just paraphrase it, but basically it says an agency is only required to provide the record in the current medium. What does that mean? Well, it's hard copy versus electronic. So let's say an agency has records in their hard copy, their paper, and there's no electronic version of them available. But someone submits a right to know request. They do it by email, and they say, I would like these sent back to me by email. And they do that for two reasons. First, it's easy. Second, there's no charge for electronic records. Well, based on the language in Section 701, the agency, if they only have the records available in hard copy, is under no obligation to scan those records in and send them by email, because that would be converting them from one medium to another. And under Section 701, you see how this works. You don't have to do that. So let me repeat this. You are under no obligation to scan in an otherwise hard copy record, because that would be converting it to electronic medium. Okay, so you're never required to scan in a record. Now, if you choose to scan in the record, which, here at the Office of Open Records, we do that all the time. Now, most of our records are already electronic, but if we're sending out something hard copy, we don't. We just scan it in and email it to them, okay? Because it's just easier and it's cheaper, so that's what we do. But you don't have to do that, okay, under the Right to Know law. Now, if you do have it in electronic medium and they're requesting it in an electronic medium, that's how you send it. You cannot charge for electronic records unless, there's the redaction factor, which we're not going to get into here today. Now, we mentioned inspection earlier. What if someone just wants to view the records and not, they don't want copies? They can indicate on the Right to Know form that they just want to inspect the records. The agency's in the driver's seat when during normal business hours, it is convenient for that person to come in, and the agency can supervise the inspection to make sure that the person doesn't alter, destroy, or steal anything. And you can sit there and watch them. However, if they pull out a cell phone camera and take a picture of the record, they are allowed to do that. Okay, there's case law that says that's acceptable. You cannot charge for your labor. You cannot charge for any redactions that you have to make unless it involves, actually a manual redaction where you have to print out a piece of paper in order to do it. And you can't charge for legal review, meaning that if your solicitor or maybe outside counsel charges you X number of dollars an hour for legal services, you can't pass that on to the requester. It's just considered the cost of government doing business. You can only charge for actual costs, or what are known as pass-through costs, which, for instance, postage is a good example, where if you can document it's going to cost $3.15 to mail this packet of records to this person, you can add that $3.15 onto the cost, you're invoicing. More payment issues, well, no surprises. I've said it ad nauseum here. There's nothing wrong with talking to a person about their request. Okay, so what I recommend is when you get a right to know request, do a quick estimate and call them up, because again, there's a lot of misunderstanding. Many people think the right to know process is free, and it's not. Okay. And we actually do another webinar on right to know law and payment issues. Probably be pretty useful to sit in on that one. But, ask the person, are you willing to pay, the $30 it's going to cost you for this response? And sometimes, they're taken by surprise. Whoa, wait, I thought this was free. No, I'm not going to pay that. I'm withdrawing my request. Okay. Could save you a lot of time before you start working on it and making all the copies. Now, pay attention here, because this was mentioned earlier. The way the right to know law reads is that records are provided upon payment. Now, let me emphasize something here. The 5 business day deadline and the 30 calendar day extension refer to when the agency provides the response, not the records. So you can grant a request. You can send a letter to them saying, hey, your request, we're honoring it. We're going to release these records. However, it's going to cost you, $30. And we will provide the records once we receive payment and your check clears. Okay, so you allow a reasonable period of time, check clears, and then I know it's subjective. What is a reasonable period of time for mailing these out? Typically, it's a couple days. It shouldn't take you more than a couple days to mail out the records once the payment has processed. Okay, but that can be beyond the deadlines, because the deadlines only refer to the response. The right to know law does not reference specifically when you provide the actual records, and it can be after the payment has cleared. Now, let's say you get a right to know request, and it's a big one, and you do a quick estimate, and it's going to exceed $100. You can demand what I call a security payment for the total amount before you begin processing the request. Okay, so you get the check and you kind of hold it, then you process the request, and then you settle up on the exact amount when it comes time to actually provide the records. It could be a little more, it could be a little less, but you have their check, which is kind of like a security deposit. So that, I think the intent of the right to know law in this specific provision was so that you wouldn't get stiffed, okay, with doing a lot of work or an expensive response without, having some sort of insurance for it. Okay. And then we come into record discard. I don't want to spend a whole lot of time on this, but basically what that says, if you generate a response and for whatever reason you didn't get payment, you are obligated to hold on to the response for 60 calendar days, after which you can dispose of those records. Okay. But the charge, the expense, does not go away. If you did everything you were legally required to do to prepare the response, and you're waiting for payment, and that payment doesn't come through, that debt does not go away. Okay, there's no statute of limitations. Doesn't go away after a year, doesn't go away after 5 years. And pay attention, if there is an outstanding debt due to non-payment of a previous request, any subsequent requests can be denied because of that outstanding debt. However, make sure all your I's are dotted and your T's are crossed as far as how you calculated the expense, all the correspondence that you had with the requester, because it is a denial and it can be appealed. So the appeals officer will be looking at, okay, what took place here? You need to be able to tell a story that you did everything appropriate and how you calculated it, that the person had a clear understanding as to what they owed and why and so forth. If you go to our website, we have a thing called the Final Determinations Database, which includes every decision that this office ever issued. It's like over 30,000. You can search on, a simple text string. You can put in the word fees, and a couple dozen decisions will come up. And you will see that the Office of Open Records usually has agreed with the agency when it comes to these non-payment appeals. Okay, but you need to make sure you do your paperwork. Okay, make sure it's all in order when you do that. Okay, let's say you have denied the request. Well, there's a specific format that you need to do or need to follow in your denial letter back to the requester. First, you need to describe the records that have been requested. Why do you do that? Because sometimes it's not clear. So you need to put it in your words. And you understand, I'm speaking to the agency side here. Sometimes people will be unusually vague with what they're asking for, and you don't fully understand. Okay, our website, openrecords.pa.us. No, .gov. I'm sorry, that's the old one. Okay. Okay, now back to the slide. Yeah, so in your denial letter, you say, these are the records we think you're requesting. Then we say, we're denying your request because, and here's where you provide the legal and factual grounds for the denial. And this is where the rubber hits the road, because if you go back to the beginning, remember, the agency bears the legal burden of proving why a record is not public. So you would be referring to, one of those exemptions within the right to know law, maybe one of those federal or state laws that says this is confidential, maybe attorney-client privilege, but this is where you make the nexus between the records that are being requested and the reasons for why you believe these records are not public and you're not releasing them. Then you put down that contact information for the arrow. Remember, this is the person legally responsible for responding to the request. The date of the response, because another deadline kicks in on the date that the request was responded to. And then the procedure for filing an appeal. And usually that is, you need to contact the Pennsylvania Office of Open Records at their website, okay? openrecords.pa.gov. And we say that, again, because you can file an appeal on the website, okay? So that would be the format for your denial letter. Now, at this point, the requester has 15 of our business days here at the Office of Open Records to file the appeal. Okay, and like I said, they can do it on the website. When we receive an appeal, there are 4 elements we look for when we're screening it. We need a copy of the original request. We need the agency response if there was one. The person then needs to tell us why they think the records are public, and they need to tell us why they think the agency's reasons for denying the request are incorrect. If any of these 4 elements are missing, we will issue what's called a deficiency order and give the person 2 or 3 days to correct the deficiency. If they do that, well, if they fail to do that, we will dismiss the case. If they do that, if all 4 elements are present, the case gets docketed. Okay. Docketed means it gets assigned a number, it gets assigned to an appeals officer, and it gets entered into our docketing system. And notification goes out to all of the parties, the person who filed the appeal and the agency open records officer, that we have an active appeal here at the Office of Open Records. And this packet, usually it's an email, but occasionally we will have to mail them out. But this packet will include instructions, an explanation of what's going on here, how to proceed, et cetera, et cetera. Now, if you are an agency open records officer or the person responsible for handling right to know requests, and you get a copy of one of these notices of appeal from our office, folks, this is the most important thing you'll hear here today. Run, do not walk to your solicitor's office and notify them that you have an active appeal from the Pennsylvania Office of Open Records. The reason being is that everything I've described up to this point is administrative in nature. Once an appeal is filed, it is a legal action, okay? Our office has been defined by the Pennsylvania Supreme Court as an independent quasi-judicial tribunal, okay? That's a mouthful, but for our purposes here, we are a court. And all of those deadlines, okay, suddenly become incredibly important. Your solicitor will know how to respond to a right to know appeal. As the agency open records officer, you are not expected to. Okay, so do not try to respond to a right to know request on your own, or a right to know appeal on your own. Requests are fine, appeals, no. And the reason is that you need to follow, certain legal procedures. You need to use certain language. There are certain forms that you must file, okay, because this is a court action. Essentially, it sounds a bit exaggerated, but basically someone is suing you. Okay, so you need a lawyer to know how to proceed accordingly. It could be as simple as you don't have the record, and your response to the appeal might be a note that says, "Oh, we don't have this record." However, that's not good enough. It's not acceptable for the appeal to proceed. You haven't met your burden. Actually, what would be required would be an affidavit from the agency open records officer prepared by the attorney that says something to the effect, I am the agency open records officer. I am the person responsible for oversight of these records. I have conducted a good faith search of all our records, and I have determined under, penalty of perjury that these records are not in the possession of the agency. And I signed this under penalty of perjury, and a seal was attached and said, you get my drift here, okay? It needs to be legit as far as the legal requirements go in order for it to be entered into the record for the appeal to proceed. Your solicitor will know how to do that. You're not expected to know how to do that, okay? That's why this is an important point. Okay, a couple questions have popped up here. Let me go over to these. Does the response letter need to identify the signer as the arrow, or can they just list their agency title, borough manager? I don't know why you wouldn't put down the name. I think you need to identify who the person is. Okay, so we know who to contact. Okay, I mean that's part of your job as the arrow. Okay, it's accountability. Can there be a partial request granted to a requester either before or after an appeal? Yes, Carolyn, that happens all the time because people will request multiple records in the same request, which they're allowed to do. And you can say, we're granting your request by giving access to these records, but we're denying your request but we're denying access to these records. Okay, so the person can appeal that portion of the response that you've denied. And sometimes you think you're granting the request, but the person isn't satisfied, so they will turn around and file an appeal anyway. So yeah, getting back to your question, you can do a partial grant, partial denial in the same response. That happens all the time. Okay, is it a conflict of interest for the arrow to file a right to know request within their own agency? Whether it's a conflict of interest or not is not something we are concerned with. Interestingly, back when I was the agency open records officer for the Office of Open Records, I actually saw this happen, where an agency secretary was also the agency open records officer. She got involved with a dispute with one of the township supervisors, and she filed a right to know request with her own agency. Yeah, it happens. Maybe it's a conflict of interest. I don't know, but we accepted it. Okay. Can they sign using their name and agency title, or do they need to include arrow in their signature? Okay, legally, it doesn't make any difference as long as the person responsible who has the legal authority to respond on behalf of the agency is the person identified in the response. Okay, I think, we're trying to split hairs here. And what I'm telling you is that there is no set legal format that makes the response legitimate or not. If the agency responds, they should identify it as coming from the arrow. They should identify who that person is. I'm not using the word shall, okay? I'm saying what they should do. If they fail to do that, it doesn't cancel out the response in any way, okay? It just makes things a little more confusing, which, sometimes that's the way agencies do business, unfortunately. Okay, but that's what they should do. Okay, so that's the best answer you're going to get out of me, Ms. Greer. Okay, I want to move on. We're at the end. Yeah, we're real close to the end here. Okay, the product of an appeal is a final determination, which is the ruling that I've already referenced here. We have 30 days to issue it from when the appeal was filed. These are available. Number one, they're available on our website. Number two, if you have access to one of the legal services like Westlaw or Nexus or Lexis, you can find them on there. If you have the docket number, you can actually do a Google search and they'll usually pop up. All right, but they carry the weight of law and they look just like you would see coming out of your county court of common pleas or the Pennsylvania Commonwealth Court. Very similar in format and logic and so forth. There is the option of mediation. Sometimes you just get the parties talking to each other. What has to happen is when the person files the appeal, we ask them, would you be interested in mediation? And then when we send out the appeal packet to the agency, we have a form in there. Hey, if you're interested in mediation, this is what it's all about. We have trained mediators on staff. And if both parties agree to mediation, sometimes all it takes is a conference call. You get the parties talking to each other and they're able to agree on how to proceed. If they can't agree, well, then it gets pulled for mediation and gets put back into the regular system. Okay, I'm a bit confused on deadline for response, but not necessarily produce the requested documents. Okay. Chris, a response is the agency saying we are either granting or denying your request, but they're not necessarily providing the actual records. Let's walk back through this. You file a right to know request. Okay, I have 5 business days to provide a response. So I send you a response. That response says, I'm going to grant your request. I'm going to give you the records you're asking for. But there's a cost because I have to make copies. So you send me the cost of the copies. And let's just say for purposes of this example, it's $5. Send me a check for $5. And when I get that check and it clears, I will then provide you with the documents I am granting you access to. Okay, now I can do that beyond the deadline because the deadline I've already met by providing you the response within the 5 business days. The records I don't have to provide to you until I get payment for those records, if there is a payment. Okay, if the records are free, then I would send them out within a reasonable period of time. But there is nothing in the law that mandates when that reasonable period of time is. Okay, does that make sense? I'm waiting for you to type in yes or no. Sort of, kind of. Okay, chew on it, chew on it. And I think, clear as mud. Oh, come on. Oh, I don't know a better way to explain it to you. Okay, I'm only going to say the deadlines apply to the response, not the actual provision of the records. Chris, if you need further discussion on this, call our office, okay? And we'll spend as much time as we need to do. Okay, Elizabeth, would the agency's willingness for mediation be determined by the solicitor? Yeah, it's the solicitor who's determining it, but the solicitor works for the agency. So, they provide advice. They also do what the agency ultimately decides what they want to do. So, I think there's some give and take there. ultimately is to get the documents, not just the response. Yeah. I mean, if the agency grants the request, you're getting the records. Okay. It's just that you don't always get them for free. If they have to make a bunch of copies, they have a right to get paid for making those copies. And yeah, okay, there we go. Okay. I think you're getting it now. Yeah. And I'll be honest with you, I have to explain this every time because there's a lot of misunderstanding that the deadlines apply to when you get the records, and it's not. It's when you get the response. It may take longer to get the records, okay? And that's what I want to make clear, and it sounds like you're getting it, okay? And I appreciate that. It really is a great question, great series of questions that you're asking because of this misunderstanding. Okay. So let's move off of mediation. Judicial review. Our decisions can be appealed to a higher level court. So if we issue a final determination and either the appellant, the requester, or the agency doesn't agree, they have a right to appeal it to a higher level court. If it's a local agency, it goes to your county court of common pleas. If it is a state agency, it goes to the Pennsylvania Commonwealth Court. You have 30 days to do this from when we issue our decision. And when you do it, you have to notify us that you're appealing it to a higher level court. Because we monitor the case, we may submit briefs to kind of educate the judge on the right to know process. And if it's an important point of law, we may request an appearance before the court. Okay, so you need to let us know as to, whether or not you're filing an appeal. And then finally, okay, I've been talking about our website. We're at the end of the presentation. So if you have any more questions, now's the time to get them in. Okay, but I want to basically let you know about this website that I've been talking about. And there's the URL for it. And if you have further questions, take a look at the website, okay, because it is a wealth of information. If you've ever sat through one of these webinars before, you know what I'm about to say. This is the best government website you will ever encounter. It is updated 6 days a week with new decisions, new court cases, training opportunities, what's going on in the world of government transparency, and the like. There are guidebooks there for the public, for agency open records officers, whomever, okay? And you're, a wealth of resources for free that you can take advantage of. And I already talked about, if you have questions, reach out to our office and we will do our best to get you steered in the right direction. We can't write requests for you. We can't respond to requests for you, and we can't discuss active appeals, but we can get you steered in the right direction as best we can. Okay, so I think we're done with the questions here. We'll be back in 2 weeks with, I think, a discussion about laws that protect information. Okay, so again, thank you for the kind words, and take care. Have a good rest of the afternoon, and we'll see you on the flip side. Bye-bye.